to Thrive webinar series. And we're pleased to be joined by Rania Sedhom today. We also have two upcoming events this Thursday on how to lease an industrial space and what you need to know in that process. That's going to be this Thursday. And then the following Tuesday, next week, Michaela Skochnik, our very own from SBIDC, is going to be giving a webinar on small business financing, particularly targeted to early stage businesses. So before we get going here, I just wanted to give a brief introduction to SBIDC. So we were founded in 1978 to support industrial businesses in Sunset Park, Gowanus, and Red Hook. And our mission is to further the success of Brooklyn's working waterfront, helping industrial manufacturing businesses succeed and grow, creating well-paying jobs for local residents, and proudly continuing the tradition we have here of high-quality products that are made right here in Brooklyn. So towards these ends, we provide a range of services to industrial businesses, from financing assistance to help with government incentives and regulations, to connections on real estate searches. And SBIDC also runs the Brooklyn Workforce One Industrial and Transportation Career Center, where we provide free recruitment services for industrial businesses and help to place interested job seekers. We also do a substantial amount of engagement on policy issues to industrial on policy issues that are relevant to industrial businesses and preserving industrial space at the city and state levels, and just trying to make sure that the voice of industrial businesses is heard throughout that policy process. So my name is Brady Mikesell. I'm the Economic Development Specialist with SBIDC, and I handle our navigating government services, whether that's providing assistance around how you can access a city, a state, or a federal incentive for your business, helping to facilitate discussions with city agencies, permitting, regulatory compliance, and I also handle our real estate services, so facilitating connections for businesses to available industrial spaces that are for lease and sale in the IBZ, as well as to real estate brokers and attorneys. I'm going to put my email in the chat. If I can be of assistance on any of these services to your business, don't hesitate to reach out. And we're also joined here today by my colleague, Michaela Skochnik. I'm going to hand it over to her to give an introduction of herself.
Hi, everyone. Hope you can hear me well. My headset is a little bit low, I've been told. My name is Michaela Skochnik, Industrial Programs Manager with the SBIDC. I handle mostly the financing assistance side, also, helping businesses access, providing them in contacts with lending partners, providing some of our educational programs, managing our educational programs, also managing EQID, the program that SBIDC has been working on to identify and develop worker cooperatives, as well as helping out with some of our policy and advocacy initiatives. So yeah, back to you, Brady.
Great, thank you. And we're excited to be joined today by Rania Sedhom, the managing partner of Sedhom Law Group. And Rania has been a consistent source of legal guidance for many of our businesses here in Southwest Brooklyn. And we're really glad that she can be here to speak with us today about the changing nature of employment law, especially around some of the circumstances arising with COVID-19, and everything that you as an industrial business should keep in mind. So I'll go ahead and turn it over to Rania to start the discussion.
Thanks so much. Thanks for having me here, and thank you for supporting Brooklyn businesses. As we were speaking earlier, I started supporting Brooklyn businesses because nobody else seemed to care about them, and I'm glad that there are organizations like yourself to help support everyone. So as Brady said, my name is Rania Sedhom, and I'll be speaking to you today about various employment issues, including COVID. But the time that we have together is really for your benefit. So feel free to ask questions as I go along. There's plenty of time that I left for Q&A, and I just want you to get as much as you possibly can out of today's discussion. It's certainly not a lecture. So please chime in, ask questions, and learn everything you can. Okay, so, the dreaded C word, COVID. We've been speaking about this pandemic and what it's been doing to businesses for, oh my gosh, I guess 2 years now. It's March 2022. I can't believe it. It's been 2 years. And if anyone was like me, they thought, oh, this is something that's going to go away pretty quickly. And then as the clock started ticking, I realized, and probably everyone else realized, it's not going away very quickly. And we're still discussing it today. While most of the special COVID laws have expired and have not been renewed, there are some COVID laws that you should be aware of here. And one of those laws is that every single person needs to be vaccinated in order to, keep their job in New York City. And as a result of that, employers are required to pay 4 hours of paid sick time for each COVID injection that's received by your employee or to accompany the employee's child. And this sick time is in addition to any other sick time that you may offer. As everybody knows, New York requires you to offer up to 5 days or 40 hours worth of paid sick time, depending on the size of your business. Let's just presume that most people here have less than 100 employees, and therefore 40 hours is the requirement. These 4 hours are in addition to it. Also in addition are these 5 additional sick days when an employee provides you with a quarantine notice from the Department of Health. And that notice is, very easy to obtain, by the way, in case an employee, grumbles and says, it's hard. It's very simple to obtain. If you want information on how to obtain it, you can, reach out to me afterwards and I can send you a link. You can probably, although I don't advise people to Google things normally, this one is an easy one. You can Google quarantine notice, Department of Health, New York, and find the steps very easily. So once that individual provides you with the notice, it means that they took a PCR test and that they tested positive. It does not mean that they took an at-home test. That doesn't count for purposes of getting these additional 5 paid sick days. After you, as the employer, provide these additional 5 days off for COVID, the employee can or may receive New York paid family leave. If you guys recall, when the New York paid family leave was initially became a law, it was not to be used to take care of yourself. It was to be used to take care of others. But there's an exception in the New York paid family leave to take care of yourself with respect to COVID. So this will help employees who have COVID, bridge that financial gap because they can't come to the office, and they should certainly not come to the office. Now, how many times do you as an employer have to pay these 5 additional days? The bad answer is 3 times. So that could be up to an additional 15 days that you're paying of paid time off. It is an expensive proposition by our state government. And the individual can use it up to 3 times. One of those times can be to care for a child of theirs, but they could use all 3 times for themselves. As we may know from personal experience, whether it's for ourselves or others, it seems like once you get COVID, you are prone to get it again, unfortunately. So this is what the law requires. If you want to be more generous, of course you may, but at a minimum, you must follow these regulations. Any questions thus far?
Okay. Yeah, could I quickly ask Rania? So, if you already provide a package of sick time and PTO time, is this fully an additional,
Yes.
Okay.
It is. It's specific to COVID. It's additional. As long as you get this quarantine notice. And the 4 hours is also, for per injection is also an addition. Okay, next slide, please. Okay. So effective December 27 of last year, you might have remembered that the then Mayor de Blasio told all employers, if someone is going to be working on site, and on site, by the way, does mean a car or van if you're not alone in the car or van. So if you're like a 2-person on a delivery route, that's considered on site. You must receive at least 1 vaccine and receive a second dose, unless you took Johnson & Johnson, which is fully only 1 dose, within 45 days of your first injection. And those individuals who cannot or will not be vaccinated either lose their job or, if possible, depending on what they're doing, need to work from home in perpetuity. That's essentially the accommodation that's available. This law, hasn't changed. We've heard a lot of things about easing restrictions. This is not one of those restrictions that has changed, and I haven't heard that it will change anytime soon, but time will tell, of course. Companies who require everyone to be vaccinated need not require masking on site. There are some exceptions, of course. If you're working with food, if you're a healthcare worker, I don't think that's applicable to anybody here. But in any event, if you do not want to require masking in your office or workplace, you do not need to require it as long as you can assure everyone that everyone is vaccinated. Now, as you might have heard, Governor Hochul and now Mayor Adams have been loosening some of the restrictions. And the New York State restrictions were loosened March 2nd. Ours loosened yesterday. And the loosening is that to go into public places for entertainment or eating purposes like restaurants, museums, sporting events, movies, etc., you no longer have to wear a mask and you no longer have to show proof of vaccination. So if you are in one of these industries, you have to still wear a mask if you're preparing food, but you no longer have to wear a mask outside of the food preparation, and you don't have to ask people at the door. That being said, companies can create their own policies. So if you as a business owner want to continue to require masking, you're permitted to do so. Before, when people were requiring it, there was no pushback from employees because it was a law. So now you just sort of have to see what your workplace is like and determine what, if any, issues may arise if you continue to require it, but your employees grumble about it. Perhaps they're all vaccinated. Any questions here? Okay, next slide then. Yes, okay, great. So this has been a very, very busy year for regulations. And I anticipate that we will be continuing on the regulatory bandwagon for the next couple of years. And we have new laws both in New York State and in New York City. So I will just run through, very short, description of what all these laws require now. And the effective dates are on the slide. So the Silence No More Act is about silencing usually women, but it doesn't have to be women, when it comes to signing settlement agreements related to discrimination. Right? One of the issues that we've been hearing with the Me Too movement is that no one is talking about what happened to them. It could be fear of retaliation. It could be these contracts where, they sort of resolve their problem internally, but they're not allowed to discuss it. So now, starting this year, you cannot obligate somebody to sign one of these settlement agreements and also tell them, do not discuss, how much you've made or the contents of our agreement with anybody. That's off the table. Another new law is the expansion of employer record retention requirements. Does anybody know prior to this year how long, for example, you had to keep a resume of somebody who just sent you their resume? Hey, interested in working for you, here's my resume. Does anybody know how long you had to have kept it before January of this year? No, it used to be 1 year, but now, can anyone guess how many years you have to keep it? Anyone? 4 years. You have to keep it for 4 years. So You can keep it electronically. You don't have to keep a stack of paper if you actually get resumes mailed to you. I still get that, which is pretty funny. Usually people send it electronically, but anyway, 4 years.
This is, sorry, Rania, this is
Yeah.
even for folks you haven't employed necessarily. It's just an interested person who sends a resume.
Yes.
Wow.
Yes. This is outside of the scope of what we're talking about today, but believe it or not, there are causes of action for not getting a call for an interview or not having an opportunity to interview for a job. There are available lawsuits, depending on what the candidate can show or not show, and therefore by obligating you to keep the resume, it helps them if there is, a valid reason for their lawsuit. Okay, this next one, enhanced whistleblower protections. This is a pretty, serious one. Prior to the deadline or the new effective date, whistleblower protections was only available to individuals who were reporting something that was illegal that affected the public health and safety. So, for example, if I went to Brady and I said, listen, Brady, it's not right that you won't provide anybody with a harness when they're, washing the windows in the exterior of the building. It's 9, stories high. A ladder is insufficient, right? Or whatever. That's a whistleblower because it affects the public, safety. Or if Brady's a food manufacturer and I'm like, listen, I've told you that our pipe is leaking into the food that we're producing and you're ignoring it. We're going to get too many people sick. This isn't right. You need to fix it now. That's a whistleblower, or it was a whistleblower. Now, whistleblower protections attach to any complaint by an employee. And the complaint doesn't necessarily have to be correct. So I might say, Brady, you are not paying us properly under the New York labor law. And I could be wrong, right? I genuinely believe that there's a mistake or purposefully bad act, whatever it is. My belief is genuine. I'm protected. It doesn't have to be that I'm correct in my complaint. So that's sorry, my light went out. Is this okay, or should I get up and put the light on?
So no, we can still see you well. Yeah.
Okay. So yeah, it's on a timer. So I guess I have to keep moving. So now, as long as the individual who's complaining genuinely believes that they have a claim, there's whistleblower protection. So that's something to keep in mind as an employer, very important. Okay, next we have electronic monitoring notices. As you may know, in New York, you have no expectation of privacy in the workplace. That being said, you now have to advise your employees if you are monitoring them and how you are monitoring them. For existing employees, you put a poster up. If someone is working from home, you email the posters. But for new employees hired on or after this day, they have to acknowledge it. So it's more than just telling somebody, hey, I'm monitoring your email. Say, no, you acknowledge that I'm monitoring your email. Maybe you're doing more than that. Maybe you have some kind of, keystroke monitoring system, whatever it is that you're doing. Now you have to advise employees about it, and new employees have to sign off on it. Now, that doesn't mean they can opt out. That's not what this law is saying. But you do need to obtain their signature so that they know that they're being monitored. So that's something a little bit new and different.
So what happens then if you have an employee that says like, oh, I'm not okay with this, I'm not going to sign to acknowledge?
Well, that's a great question. As with any, employee policy that you have, it's your choice whether to, make an exception. As an attorney, I don't like exceptions because exceptions ultimately lead to some kind of discrimination claim, right? Because how come you gave an exception to her and not to me? It's just a bad conversation. But in any event, it's up to you. You can, one, make an exception. Two, you can suspend, the employee until they follow the rules. You can terminate the employee because they're not following the rules. I mean, there are options. None of them are great. I think that it's, something where you need to educate them and say, this is not a change. Unless it is, right? If this is like a new policy for you, then you can explain why you're doing it. And if you're in, any kind of industry that has truly confidential information, it makes sense that there would be some monitoring, right? Or if you have, some kind of proprietary recipe or way of doing things, it makes sense you'd monitor. And to the extent that it's not new, it's a very, easy notice. It's like, as we've always done, we're continuing to do this, that, and the other. And I know if you've worked with me, I've already included this verbiage in the employee handbook. And so it should come to as no surprise to employees. But unfortunately, it's not an easy choice. If someone refuses, it's like refusing to do any of the other, things that are on your to-do list for the employee. What would you do then? And then we're a little bit far away from January 1, 2023, but starting next year, you can now, you will be able to use your New York paid family leave to take care of your sibling. Right now, you cannot. Starting January, you may. Okay, next slide, please. Okay, so these laws apply only to us here in New York City. So if you have a company that's both in Brooklyn and a second location in Long Island or New Jersey or anywhere, this only applies with respect to your New York City location and New York City employees. So the first one is probably the most controversial. It seems, deceptively simple. It's not that simple in my opinion. I'd be curious to hear your thoughts. But starting in May, when you post a job, and that could be internal or external, this is not only for hiring people outside your organization. It also includes, any kind of possible promotion, right? Because there's a new job open. You have to disclose a good faith salary range. We are still waiting to find out what that actually means, right? Because sometimes, for example, you could be looking for someone with 5 to 8 years experience. It's likely that the salary spread will be quite large between 5 and 8 years. Maybe not, it depends, right? But it can be. But this is causing a lot of distress for a lot of my clients, particularly, smaller companies that may not compete on salary. They may be competing with other things. They may compete on benefits. They may compete on flexibility. Well, none of those items are mentioned or need to be mentioned in your posting, but the salary does need to be mentioned. And if you do not post it, you have committed an unfair labor practice. Do you know, or can you guess what the fine is for failing to adhere to this law? It's a doozy. That's a hint. It's a doozy. What do you guys think?
$500.
$500? Not even close.
Not even close.
10,000? 10,000?
More than 10 times that.
Oh my God.
$125,000. Wow. More like, probably more than what the salary is that you're paying. Yes.
And
it's a doozy.
This is like this is even for an Indeed posting, for a LinkedIn posting, for any
Yep. Otherwise, you're discriminating. It's an unlawful discriminatory practice. You must post it. Yes.
And is this attached to only the job posting itself, or say you want to promote on your social media page or through, emails to people, do you have to, in those posts, also make reference to the salary, or is it only that central post that this is tied to?
If you are discussing an open position, you have to disclose the salary. How you post it doesn't matter. If you're gonna like just have a box on Instagram that says, we're hiring, well, you need to say we're hiring and we're paying between this and that, or whatever it is. Yes, all postings. This one's a doozy. It's a big one. I'm hoping that we get some, I guess, regulations or clarifications around it soon, but it's already the 8th of March and the clock's ticking. So do your best. Excellent question. In case I guess I'll read it aloud. Can you not make a very large, oh wait, it disappeared, hold on. Can you not make a very large blanket range to cover it? I don't believe you can do that. It's a great question because it has to be a good faith estimate. So I don't think you can say we're looking for a director of business development and we're going to be paying between $50,000 and $150,000 depending on experience. I don't think that's going to cut it. And this is one of the issues that a lot of the lawyers have been discussing with the legislatures. We're like, we definitely need some guidance. It's not as easy as you guys think it is because you're not always hiring for this one position with very narrow parameters, right? So if you're saying we're hiring for a receptionist with 8 years experience who can speak English and let's make up any language, I don't know, Spanish, who has worked in our industry, I mean, okay, then you probably can come in with like $10,000 to $12,000 of what you're going to pay. But that's not how life works, right? Sometimes we don't even know. We can place an ad for 3 to 5 years and we get candidates for 5 to 8 years. And all of a sudden we're looking for 5 to 8 years. And we don't even know. And I know with smaller businesses, sometimes it's a catcher's catch can kind of an environment where you need a great employee and this employee is going to wear many hats. You just really don't know what is a reasonable compensation to offer the person because they're going to be doing operations, they're going to be doing fulfillment, they're going to be doing reception duties. What does one pay this person? Anyway, all of these unanswered questions. So this one, hopefully we'll get more information about it soon.
Is there any issues, say you have a posting and you put a range down and say you get some candidate that is, more than qualified and say you end up, offering a salary that's above that posting, or, say you have a posting that, is for a very qualified candidate and you get someone that's a little less experienced and maybe a better fit for a lower, for a different tier of, what you'd be offering. Is that an issue if you offer either below or above what the job posting range is?
Those are great questions, and those are actual questions that I've asked. And I don't think that this was fully thought through. That's number one. Just my personal opinion. Please don't audit me for saying something adverse to a law. But I don't think those things were considered. I just think it was more, a law that's there to protect employees so they don't get, the switcheroo. Like when you go shopping and there's, this television's on sale and you get to the store at 8:30 in the morning, 5 minutes after it opens and it's sold out miraculously. And then you only can buy the very expensive TV. I think the thinking was they don't want you in your head to say, I'm willing to pay $70,000 for this job, and then in walks somebody, you have some kind of discriminatory inclination, consciously or subconsciously, and now you offer this person 60,000. But if it was somebody else, you'd offer them 70. I think that's the problem this is trying to solve. but this is creating problems because, again, everything's not so neat and cute and fits in a perfect box. And so I don't know the answers to those questions. We're waiting, not so patiently, but we're waiting for answers to these questions. I think if you were my clients, my advice to you would be change your ad. So if you have a posting for 5 to 8 years and it's, whatever, 50, I'm making this up, 50 to 70,000, and in walks like 3 or 4 candidates that are 8 to 12 years, and you want to pay them more, post an ad for them. And then you can hire them on that ad. Same thing for you're getting 1 to 4 years and you're unwilling to pay 50 to 70. You're only willing to pay 30 to 49. Post that ad. I have not seen any rule. I don't want to give anyone any ideas, but I haven't seen a rule yet about how long you have to keep an ad up or how many ads you can have up at once, right? So I don't think there will be any laws curtailing your ability to hire as many people as you want. And there's also no law yet that if you have a posting, you must find someone for that posting, because any business owner knows sometimes you're looking for someone and that person does not walk through the door. And then you have to think of, okay, well, what other job can I fill? Because I'm not filling this one right now. So I would say the most conservative approach is post another ad, and then you can hire that person for more or that person for less, and keep this particular job, the initial one, open until this person is found, wherever it is that they're found. So that's this is a big one. Okay, another one, probably not as controversial for most people. It's the Enhanced Fair Chance Act. This is taking place this summer. And this law is really just more of what you already know about criminal backgrounds. Just a quick primer in New York City. And this is really kind of the law in most places, but we're focused on New York City right now for purposes of this slide. So in New York City, if you want to check somebody's background, whether it's credit, criminal, or anything else, you may do so under 2 circumstances. Number one, it has to relate to the job, right? So if I'm going to be a delivery person for you, definitely check my driving record. That makes perfect sense, right? But does my credit matter? I don't know. We have to talk about it. So number one, is what you're checking, does it have anything to do with the job? If it does, great. That's prong 1. Prong 2, it must be contemporaneous with a job offer. So it can't be you apply for a job, I then check your credit and then make you an offer. That's not permitted. I have to make you an offer that's contingent upon you passing some check that makes sense and is related to your job. Now, this Enhanced Act is saying, if you're checking periodically, because some industries do that, in the banking industry, this is, like widespread, they will spot check your backgrounds because they're saying things like you're dealing with other people's money. That may or may not be true, by the way, but that's what they're saying, right? I mean, if you are like the security guard at a bank, you're not really dealing with anybody's money, but that's fine. So banking, notorious for this. Financial advisors, also notorious for this, but this happens in other industries as well. I can tell you in fashion, I've seen it happen. So this law protects your current employees as well. And therefore, whatever you had to do, if the person was a new employee or a candidate who was offered a job, you have to do to your current employees. And that is, if you're going to check and it's related to the job and you find something, you have to talk to me about it, because I might be able to give you some insights. Maybe there's a mistake. A lot of us, not me, but a lot of us have names that are relatively common, and sometimes things get confused. But even with a name like mine, where there aren't too many of us, I might be the only one of us actually, there's a website you can check and see how many of you there are by name in the world and in America. It's pretty interesting. even then, it doesn't mean that someone couldn't have lifted my social security number and assigned it to a new person. But when you're doing these checks, sometimes it's done based upon a number more than a name. So you have to sit down with a person and say, hello, I found these issues with your, credit. I found these issues with your driving record. I found these issues with your criminal record. Are these things true? And then, you have to make a decision based upon what the person tells you. Okay, this last one is about AI. I'm not sure if anybody is using AI to help hire, fire, and promote. I do not, but I know larger companies, tend to automate anything they can possibly automate. And that includes hiring, firing, and promoting at certain levels of an organization. And so starting next year, if you are going to use this, these AI protocols, you're free to do so, but you have to audit them to make sure they're not having a discriminatory impact. So I've never used this kind of software before, but I'm imagining, as with any technology, we program it, right? I push a button on my keyboard and it tells the computer, put an M on the page. It's really me, right? I'm the one who's typing. It just makes my life easier. So I'm imagining that you are putting in some parameters for this machine so they can comb through tens of thousands of resumes and give you 10 of them. Because who really has time to go through tens of thousands of resumes? I don't. I'm sure nobody on this Zoom call does. So to the extent you're using it, you have to conduct an audit, you have to provide the report, and you have to allow people to opt out of using any kind of AI technology for like testing. So I don't know how many people will continue to use it. I couldn't tell you that, but that is what is going to be happening starting next year. So we have a lot of new laws. So next slide, please. So again, I thank you for letting me speak to you. We still have time for Q&A, and I'm sure there are going to be questions. If not, I can keep talking, but I really prefer to hear from everybody on the Zoom. But as a thank you for listening to me and for being here today, you will all receive, to the extent that you want it, a 30-minute complimentary consultation. And then if you end up hiring the firm, you will get 20% off of all your legal services for an entire year. So that's my way of saying thank you, paying it forward, and helping us, all get over this COVID hump. I'm going to be positive and say it's just a COVID hump, and then things will be much better toward the end of the year and into next year, financially for everybody. So thank you all so much. It's my pleasure. Thank you for having me. I had a great time speaking with everybody and answering your questions.
Yeah, thanks so much, Rania. This is a super informative session. We really appreciate your time and being able to share your expertise with all of us. And just a reminder to the businesses on the call as well, we've got 2 upcoming more events in the Stabilize to Thrive webinar series. It's this Thursday coming up. We're having our session with real estate broker Rich Novak and real estate attorney Justin Wazer to discuss the logistics of leasing an industrial property. And then finally, a week from today on Tuesday, our very own Michaela Skochnik, who you've heard on the call as well, is doing a webinar on guidance for financing for early stage businesses. So thank you again, everyone, for joining us. Hope you have a great rest of the day, and hope to talk with you all soon.
Thank you, Rania.
Thank you.
Thanks, Rania.
Bye. Thanks, everyone.
Are we still recording now?